Yes.
My lord, miscellaneous appeals. Before vacations, I mentioned this matter.
Business appeal for order 41 hearing or hearing, final hearing?
Yeah, order 41, rule 11.
Yes.
My lord, application.
Please.
Same application.
Application, please. Application. Yes.
My lord, for inclusion in list.
What matter?
It's a matter.
First asserted, then come. Yes.
Your lordship, this is a order 41 application.
Yes.
It
Order 41 is mentioned.
may permit a hearing matter, your lordship.
Hearing.
My lord, with the leave of Honorable Justice Supratim Bhattacharya, may I be permitted to mention a review matter, my lord, pertaining to the bench presided by my lord and Honorable Justice Uday Kumar.
Please hand over. Will
My lord.
whenever the
Lord,
bench
it's
sits.
a
Lord,
restoration
deeply
matter
obliged.
for inclusion in list.
What is the matter? What is the heading? Under which heading?
Inclusion. It's a.
No. Sorry, not now. Yes.
May I have my lord's kind leave to mention a matter? My lord, this is an appeal from a decree.
Appeal hearing we are not taking. Yes. Call on the list.
My lord, for restoration.
Application, yes.
If I am mentioning, my lord, item 88 of your today's private lordship, my lord. It is an writ petition filed by the state and its authorities challenging an order of the Land Reforms Tribunal, where, my lord, the Land Reforms Tribunal in the year 2010 has directed the authorities to hand over the land in favor of the, my lord, the original applicant who was the sole respondent in this. My lord, affidavits have been exchanged. There is no stay order. So, my lord, now the sole respondent expired. I am appearing on behalf of the, my lord, proposed added respondent who are yet to be substituted. My lord, may some precedence be given because, my lord, the 4 applications are pending interregnum, and, my lord, no steps is being taken by the authorities to hand over the possession.
No precedence. Sorry, no. Yes.
My lord, may I?
My lord, may I permit to mention on matter order 40 on rule 11 for
Yes. Call on the list.
My lord, may I seek indulgence to appear online, lordship? And in this matter, lordship, all the steps have been taken. Only affidavit of service I'm supposed to file. Can I take for a time for 10 days or 12 days, lordship?
Which matter?
Item number 1.
Was it appearance to be mentioned?
Yes, lordship. There was a direction by lordship to.
Please give us up a minute. Hey, is there any device on in your? Please switch off your phone or other device.
Yes, lordship. Yes, lordship.
Ms. Gudkudi, you have not put in the requisites for fresh service on the sole respondent. From the office report dated January 5, 2026, it transpires that the appellant has not put in fresh postal costs as well as other requisites for service of notice of appeal on the sole respondent, nor has the requisites are directed to be put in by the appellant within a fortnight from date. Full stop. The appellant shall also file the requisite number of paper books within 4 weeks. Full stop. In default, let the matter be listed under the heading Law Zima. Next. Office K.
Grateful, lordship. Grateful, lordship.
Yes.
In item number 2, lordship, I beg to appear on behalf of the petitioner,
please, what is the
Mr.
matter?
Soposari Chatterjee, lordship. In earlier occasion, lordship, the matter was taken up for hearing, and there is an interim order passed staying in the operation of the order which have challenged, lordship. Now, lordship, they are supposed to come by today, lordship. They have now the respondent is saying, lordship, they have need some time, lordship. So
They're not saying that.
No, lordship.
You move your matter.
Yes, your lordship. That the order impugned, lordship, annexed in my memorandum, lordship, that an order has been passed for the visitation of the husband, lordship. Now, lordship, subsequently, this order has been challenged, lordship, that the child in question, lordship, is suffering from a lordship disease, and for such, lordship, there may not be possible to hand over for a particular time, lordship. So far the order is concerned, it has been specifically stated that child should be handed over on the Friday, and you will return the child on the Sunday.
To the disorder, you have to feed the child.
Yes, your lordship. That is the subject matter, lordship.
Yes, what do you say?
Lord,
we don't feel that the child should be handed over the weekend. You can come and visit.
I'm not supporting the entire order of the court below. I'm not supporting. But
you can come and visit. Definitely, we'll grant you visitation rights. But not over the weekends because the child will be in.
Only, my lord, I am paying, my lord, what I am. My lord, 2 hours in a week, Saturday or Sunday, my holiday, my lord. He's working, my lord.
But do that in the wife's residence. She'll
No,
provide a separate room for me. For you.
separate, my lord, in my residence, in presence of the any of the lawyer, because my lord, the further
child-
development. No, my lord, why you not, my lord?
But this child, this sort
No,
of a child,
but
it is not.
not before the mother, because my lord, the further development in the month of December after passing your lordship's order,
Yes.
he made an application, my lord, the criminal case against me, 498.
So there is
My
some
lord,
difficulty
see,
there.
my lord, continuing this after 6 years, my lord, in 2019, something was happened. My lord, after 6 years, in the month of December, we made a complaint before the police, and police has lodged a, my lord, a criminal case against
So
me.
you
So, my
feel
lord,
it will be risky to go and visit there.
visit there in their place and also in presence of the mother.
Is the
So-
child? Is it possible, Mr. Chatterjee, for the child to go out of the home? I mean, he goes out, goes
Yes.
to school, and other things.
Then he goes.
So 2 hours is not difficult.
And my lord,
Not
I am, my
difficult,
lord,
I will not come on the way. My lord,
We'll modify
kindly
the order and say that.
keep a separate place, independent place. I will
But
take
not
my
at
way.
your residence, Mr. Chatterjee.
Anywhere, anywhere else.
my
Apart
residence,
from
my
my
lord, in
residence,
presence of
Where does the child reside?
at my new town.
Newtown. So Newtown, is there a nearby place near your place? Near your
New
residence?
town coffee house is there. Other places are there.
Yes. What is the age of the child?
6 years.
6 years.
6 years. Coffee house. What will the child do in the coffee house?
Any other public
My lord,
space.
5 kilometers from my residence. My lord, so my lord, he
So
can.
some park or something like
Park,
that.
eco park is there.
Eco park.
Eco park. is
Eco
there.
park. We'll make it eco park. 2 hours every Saturday.
Every Saturday, 3
2
to
hours every Saturday. Hours they'll say.
And ours, Lordship, I will. কখন?
6 years. Saturday is a school day
Evening.
for the child.
জিজ্ঞেস করুন।
Evening will be difficult. I mean, for the,
I'll take the instruction. Now only I'll take the instruction.
3 to 5.
is she there or somebody there?
He'll go and make a call.
We are making it from say
And another prayer, my lord,
4 to 6.
apart from the, my lord,
Yes.
mediation.
Yes.
My lord, I am paying the entire, my lord, the fees of the school and also medical expenses. So, my lord, direct the petition to cooperate with me. I can, my lord, expense everything to, my lord, the
That you
visit
are
for
already
the-
doing. You are a good father.
Yes,
No
my lord,
doubt
the
on that.
psychiatrics and also, my lord, further prayer before Lord. So, my lord, even if, my lord, any conciliation through court, if my lordship, my lord,
What
I want
consideration?
to, my lord, so, my lord,
Because you are paying, you want more time. You are
more,
buying time.
more time, my lord, to stay with, my lord, my lord,
No,
further
he's your
face, my
child.
lord.
You are paying for your child. For that, it
That
is not a payment for visitation.
No, I am not saying that, my lord. Lord, I am paying for, my lord, for
No. Whatever you have wanted, we are giving you every Saturday from 4 to 6 at Eco Park.
and my lord, and
But
further,
you will have to strictly follow the timelines.
father also should cooperate with me for medical
We
treatment.
undertake.
So, my lord, my lord, I
shouldn't she
pay the
cooperate?
expenses.
Why should
No,
she
my lord,
cooperate for the
he's
medical?
not agree to go to before the psychiatrics or any other doctor.
That
No,
is beyond the
nothing has
scope of
been
this
done.
appeal. That is beyond the scope. If you have any particular psychiatrist in mind or any particular occasion, you can seek the leave of the trial court. But that is beyond the scope of this order. We are disposing of the appeal with that order. The present appeal.
Lordship, only one thing, let the lawyers from respective party, at least they be present on the first
What will the lawyers do there?
day.
We'll appoint you.
No,
We'll put your name in the order. We are agreeable to you. You have full faith on it. You will have to be there. For your juniors, you will have to be there.
Or, my lord, keep it, my lord, after 2 weeks, my lord, it will appear for further development. Anything.
No, not every week. This is not a monitoring by the court. Both of you be there, you and Mr. Chatterjee.
well, Mr. Karar will be there, my lord.
No, he will not be able to handle it. You have some maturity. If necessary, you can stand on a stool and give a lecture also there. No, advocates not for the time being, but we'll give you liberty, both of you liberty, if there is any difficulty in the visitation, to approach the trial court for that. And we'll empower the trial court also to modify the order if necessary. We'll put that in. The present appeal arises against an order passed by the learned trial judge in an Act Roman 8 case filed by the respondent father for custody of his child, who is a minor son of 6 years and lives with his mother, comma, the appellant. So next para, by the impugned order, comma, the learned trial judge directed the directed the appellant herein, that is the mother of the child, comma, to hand over the son Nikunj Banerjee to the respondent father in the evening from 5:30 p.m. of every Friday, and that the minor child would stay with the father till the evening of every Sunday, that is up to 5:30 p.m. For sub next para, learned counsel for the appellant argues that the child is special in the sense that he is suffering from autism spectrum disorder within bracket ASD, and as such, comma, the minor is even unable to chew his food by himself and has to be fed by the mother. For sub next para, under such circumstances, comma, it is contended, comma, if custody of the child is given over the weekend to the respondent father, comma, it would be detrimental to the welfare of the child, and precarious situations might arise in respect of the health condition of the child, comma, since the respondent father is not properly equipped to deal with such situations. For sub next para, learned counsel for the respondent father takes a reasonable stand by submitting that even if custody over the weekend is not given, comma, the father may at least be given visitation right once every week for about 2 hours. Full stop. However, comma, it is submitted that in view of complaints having been lodged by the appellant mother against the respondent father, comma, it would not be appropriate, comma, due to the acrimonious situation, comma, if the visitation is held at the residence of the appellant mother. Push up some neutral place, comma, as such, comma, is sought to be fixed for such visitation. Push up, upon hearing learned counsel for the parties, comma, we appreciate the fairness shown by counsel in taking a reasonable stand regarding the visitation rights of the minor. Push up, we are of the opinion that for healthy upbringing of a child, comma, the company of both the parents are necessary, and, comma, as such, comma, uh, 2 hours apostrophe visitation every weekend by the father would be appropriate. Full stop. However, comma, such visitation should be held at a common place congenial to the uh, health of the 6-year-old child. Full stop. Accordingly, uh, FMAT 521 of 2025 along with CAN 1 of 2025 are disposed of by modifying the impugned order bearing order number 7 dated December 15, 2025, passed by the learned additional district judge, 7th court at Barashak, district North 24 Parganas, in miscellaneous case number 99 of 2025 within bracket Act Roman 8 bracket closed, to the extent that instead of custody over the weekend, comma, the respondent father shall visit the minor child Nikunj every Saturday from 4 to 6 p.m. Footstep, such visitation shall be held at the Eco Park, comma, which is near the residence of both the parties and also congenial to the welfare of the child. Footstep, next para. For such purpose, comma, the appellant mother shall take the child to the Eco Park, comma, at a particular designated gate thereof, which will be pre-decided by the parties, comma, sharp at 4 p.m. every Saturday, comma, starting from next Saturday, that is January 10, 2026. Full stop. Next para. From there, comma, the respondent father shall take over the child and spend some quality time with the child within the precincts of the Eco Park till 6 p.m. Full stop. Sharp at 6 p.m., comma, however, comma, the father will return the child to the mother at the same gate from where the child was picked up by the father on every such occasion. Full stop. Next para. We express hope and trust that both the parents shall cooperate with each other, and be responsible insofar as the needs of the minor child is concerned. Full stop. In the event there is any difficulty on the part of the child or the parties in such visitation, comma, it will be open to the parties to approach the learned trial judge for further orders stroke modification of this order. Push up such for such purpose, comma, the learned trial judge will be at liberty, comma, if deemed necessary, comma, upon assigning proper reasons, comma, to modify the visitation right as directed by this court. Push up next para. There will be no address to cost. Starting
Or after handover the child, for mother will not present at the
আচ্ছা
time in that period.
নো অর্ডার্স টু কস্টে আগে আরেকটা লাইন করে দাও ডিউরিং সাচ ভিজিটেশন কমা দি appellant mother shall not be present at the place shall not be present with the respondent father and the child and shall not interfere with such visitation during the said appointed 2 hours in any manner whatsoever. The father, if you feel, you can take help of a medical expert also during that period. We have not put it in our order. We have full faith in your client that he will look after the benefit of his child, and if necessary, take a medical professional if you feel that if it's necessary for the child's welfare. I mean, because of the feeding problem and other
My
things.
lord, I agree, my lord. I
And
ready
you
to
cooperate with him on that.
always, my lord.
Is there a divorce suit also? Divorce suit is pending.
My lord,
Divorce suit is
divorce
also.
suit is-
No, 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 no.
No divorce suit.
they have instituted, they have.
No, no, no. I have not any divorce.
And they have.
Well, if there is no
I-
divorce suit, then
because
it can be reconciled. I mean, why do you?
my lord, there was an order of the court below. She was agreed,
Withdrawn.
but she did not turn up.
It's just,
No,
just
she did not turn up. That's why I would not.
no, during the visitation also, maybe your relation will also improve.
Yes.
Let's see, let's hope. and
So we hope
trust.
for that.
She is not, my lord, his client will not agree.
Let's.
Let us see. Mr. Chatterjee will have a talk with his client also. Yes. Thank
Item number 3.
you. Yes.
May I have my lord's leave to appear online, my lord?
Yes. Yes. Absolutely.
I beg to appear for the appellant, my lord.
Appellate. Yes.
My lord, in terms of the last order, my lord, of 19th November passed by your lordship, my lord has directed them to file their opposition reply, but nothing has been
And
filed.
yesterday, the suit was pending. Suit was taken up for hearing before the landed civil court, and already the plaintiff has adduced every peremptory hearing has been fixed, my lord. Was fixed for peremptory hearing, my lord. Suit is in peremptory board, my lord. Evidence was partly done before the trial court, my lord. It's a suit of 2022. There was an order of injunction, which has the order of injunction has been
Mr.
affirmed
Ball,
in
since
the
you have not
this-
filed any
by this court.
opposition, we'll have to proceed without the opposition. There was
My
a
lord, last chance, it's ready, my lord. We can file
no,
it by
no,
Monday,
no,
my
no,
lord.
no, no further.
By day after tomorrow, my lord. We
No,
can
no,
proceed.
sufficient chance has been given. You are trying to delay the process because the suit is on the peremptory.
No, no, my lord. It's everything is
Let
ready,
us
my
hear
lord.
the appellant, please. Yes. Yes.
My lord, then, my lord, kindly come to the
What
page.
is the appeal against?
My appeal against an order passed under Order 39, Rule 4, my lord. My lord,
Vacated.
no, not vacated, my lord. I
Injunction
have
is still
sought
there.
for vacating of the interim order. The court said, despite the liberty granted by your lordship, the court said that there is no change in circumstances. Thus, it cannot be vacated.
No, our liberty does not mean we directly.
My lord,
court can
that
very
on
well
that
hold that.
premise only, my lord, I just grant me liberty so that I
What
can
is the
take-
injunction granted?
My lord, injunction granted, my lord, this is a suit for, my lord, publishing cancellation. We have cancelled the publishing agreement. The appellant with your lordship is the writer, my lord. We have cancelled the publishing agreement, my lord. They have challenged that by way of this suit, my lord. And in that suit, they have got an interim order of temporary injunction restraining the present appellant before your lordship from preventing the plaintiff to continue the publish the book, my lord. Now, what has happened, my lord? When we by way of the temporary injunction, we have assailed as a appeal before your lordship. Your lordship has granted this coordinate bench of this honorable court has granted them to pay an ad hoc payment, my lord.
25,000 was
Yes,
paid, but they're not
but they
putting
were
in
not
quarterly statement.
quarterly statement, my lord.
So that's why you sought
That's
for
why
vacated.
then again, my lord, I came before your lordship by way of a can 2, my lord. And wherein my lord has deprecated their actions and gave me a liberty to approach before the.
Are they filing that quarterly statements
My
now?
lord, what has happened after the order under challenge before your lordship was passed, they are giving quarterly statement of their choice, my lord. For an example, the quarterly statement of January, February, and March should be given. They are giving February, March, and May.
Since the suit is on the perimeter board and at an advanced stage, we'll request the trial judge to dispose of the suit by March end. That will take care of the problems, and we'll direct them to continue
I've
putting
been
in the.
led by Mr. Basu.
Yes, please. We'll directly direct them to continue with the filing of the quarterly statements. If there is any discrepancy in the quarterly statements, we'll give you liberty to take that point at the hearing of the suit also.
And my lord,
Arguments in the suit is almost over. So suppose we'll
suit is all
Started yesterday.
peremptory
PH.
evidences.
That also, my lord,
Request the trial judge to do it if necessary by day-to-day hearing and end it by March end 2026.
very well, very well. That would be okay.
That will
And
also
my lord, to direct them to furnish the statement of
proper
account.
quarterly statements.
Proper
my
quarterly.
lord, the practical difficulty, my lord, I would say,
My
my
lord,
lord,
what they have
that
been
we are
doing
the
is-
publishers.
But
We
after
distribute
file
the
an
books.
application, an order is passed, or during the pendency of the application, they come up and file the quarterly statements of the pending 6 months, 8 months, 1 year.
2 years back.
They don't pay royalty after May.
The next quarterly statement is not due before say
Well, at May
March in any event.
2025,
March.
after that they have not paid. They have not. Well, they have not furnished. May
Mr.
2025.
Paul will direct you to file the entire pending
But the
quarterly
practical difficulty I am stating, my lord would appraise this thing, my lord. We are the publishers of the books. We distribute the books to various throughout the West Bengal, my lord. Suppose we are distributing to X 10 books. Suppose we get the money after they sell the books, after 2 months or 3 months. That is the whole difficulty, my lord.
that has to be put in your quarterly statements.
That has to be put in your quarterly statements.
Whatever is due from those people.
And
if
they,
you're-
my lord,
No. We'll no, so sorry. We'll put you to terms. Whatever pending statement quarterly statements are there, you will put in those by 31st of January, and this will be a condition. We'll say if you don't put in that, and the next quarterly statement will be due by the end of March.
March.
So you'll have to also file that before by the 15th of March. If the suit is not disposed of by then, and if you don't do that, the interim order will stand automatically vacated, Mr. Bora. We'll say that in our order.
But I have not been paying the royalties also as per the
Royalty that will be decided in the suit because 25,000 ad hoc was
as per the first order of Justice Mukherjee.
that will be decided by in the suit.
And that's not required to be decided. Well, the order was as per the agreement. They have not been paying royalty as per
But we
the
cannot
agreement.
decide that at this stage. Whether they pay.
Your lordship,
Your allegation was, Mr. Bose, your allegation was that they are not putting in the quarterly accounts.
Yes, your lordship gave me that liberty to take the point of royalty in the last order.
Take that point of royalty also in the suit itself.
So lordship would give me that liberty also, Manoj, because they have not been paying royalty. As
No,
per your
that
lordship-
liberty is already there in the suit. You can urge that point, and if you win the suit, everything you get everything.
Yes, that is.
So in any event, they'll have to because
your
you must have
lordship
paid for
would-
accounts in the suit also.
Yes, and your lordship would put them on terms with regard to the furnishing of accounts.
Yes, that we have said. It will stand automatically.
And also, my lord, the completion of the suit. Because they have been
Said
deal-
that.
Yes.
The present appeal has been preferred
Because
against.
one thing I should point it out to your lordship, for which I have taken necessary steps. My lord, they have allowed a co-publisher to publish.
That is a
No.
different
Yes, I know.
No.
that.
beyond the suit.
I know, but they are doing it.
The present appeal has been preferred against an order whereby the application of the defendant stroke appellant under Order 39 Rule 4 of the Code of Civil Procedure has been dismissed by the learned trial judge. Full stop. Next para. The appellant is an author of a book, the publishing rights of which were given to the respondent number 1 company, of which the respondent number 2 is a director. Full stop. Next para. The appellant alleges that the royalty as agreed between the parties is not being paid to the appellant. Full stop. Furthermore, by a previous order passed by a coordinate bench of this court, the respondents were directed to file quarterly statements of accounts, which is also not being filed in a proper manner, as such entitling the appellant to the vacating of the interim injunction which was passed in favor of the respondents. Some next para, learned counsel for the respondent contends that the suit is already on the peremptory board and the final hearing has commenced. First up, it is submitted that it is somewhat difficult to file quarterly statements, since the publishers uh, distribute the book, distribute copies of the book authored by the appellant to different sellers, stroke retailers, and the payments are not received in time. First up, since the distribution is made in a staggered manner, as are the payments, it is submitted that it is difficult to put in quarterly statements. For sub next para, however, this court is unable to such appreciate such difficulty portrayed by the respondents, since the order of the coordinate bench was very specific, and has not been challenged, to the effect that quarterly statements are to be filed by the respondents. For sub next para, even if the distribution and the payments are made in a staggered manner, the quarterly statements should reflect the exact dues from on that date, as well as the exact quantum of the distributed books, as well as the retailers or other sellers to whom the books are distributed. For sub next para, hence, such contention of the respondents cannot be taken into account. For sub next para, however, since the coordinate bench has already put the respondents to term and the suit has reached the peremptory board, this court is of the opinion that for the ends of justice, the suit ought to be requested to be disposed of at an early date. For sub next para, be that as it may, we also are of the opinion that the respondent should be put to strict terms in order to ensure that the relief sought by the plaintiff, that the defense taken by the defendant in the suit is not prejudged prior to final disposal of the suit. First up, in such view of the matter, FMA 1800 of 2025 is disposed of by modifying the impugned order bearing order number 45 dated July 11, 2025, passed by the learned judge, 10th bench, City Civil Court at Calcutta in title suit number 860 of 2022, to the effect that in the event the plaintiff stroke respondents do not file the quarterly statements of account, which are pending till date, by the end of January 2026 before the trial court, and thereafter file the next quarterly statements by March 15, 2026, within bracket, if the suit is not disposed of by then, bracket closed, the interim injunction granted in favor of the plaintiff's respondents shall stand automatically vacated without further reference to the court. For sub next para, simultaneously, we express the hope and trust that the learned trial judge shall dispose of the suit itself, if necessary, by taking up the same for day-to-day hearing, latest by the end of March 2026. Next para, it is further clarified that we have not entered into the merits of the respective contentions of the parties, and it will be open to the learned trial judge to decide the suit on its own merits independently and in accordance with law. First up, no orders to cause, certain certified copies, Can 2 of 2025 is disposed of in the light of the above observations.
But only one, your lordship has said January and March. But in default of any one,
any of the,
I think it has not gone.
We'll look
But otherwise, they'll extend this January to March.
No, man, would pay. By 15th of first by
two riders we have said in default, it will stand with it.
Great.
I'm grateful. I'm grateful, man.
Next.
I'm for the appellant in this matter.
Yes,
Your lordship will kindly take up my lord's order. But this is pertaining to that allotment of Koshba Industrial Estate plot.
Yes.
My lord,
There
as
were
per your
two
lordship's
things,
direction, my lord, we
Lord,
have intimated the parties
that.
you'll
Pursuant to
kindly
the
say-
land policy, whether Lord, they will give the land Lord, for further lease Lord, at the rate of 30 lakhs per kata. They have given a response by saying that they are not willing to do so because other entrepreneurs are waiting for allotment of the plot. On the second point of Lord, whether the compensation is payable, your Lordship had recorded in my Lord's order at paragraph 6 about that. And Lord, in response to that, Lord, they have given a letter which says that they can consider the question of compensation provided we provide the
But there are
document.
two letters. One is written by us, and another is replied by
এক
them.
মিনিট আমি বলে দিচ্ছি
আচ্ছা।
আমার যদি কোনো ভুল হয় আপনি
না, না।
নিশ্চয়ই বলবেন।
Yes.
So, my lord, on the point of compensation, my lord, at the second page of the letter that my learned friend's client had given, my lord, they have asked for, my lord, certain documents. That is, my lord, further in compliance with the order, that portion, my lord.
Yes, yes.
So there are 8, my lord, things that have been requested for. But these documents were sought for by 2nd of January this year. The last 3 lines you requested
yes,
to
yes.
upload. My client pursuant there to But kindly turn over to the next page. The list of enclosures gives my lord the documents that they have asked for.
Yes.
Now, my lord, it is now it is up to them, my lord, to consider this document and give my lord an indication of my lord the compensation. That is where we stand, my lord, as of now today. So they are not willing to give it, my lord, for a further lease.
So regarding
And
the compensation only.
Only the
was-
Only for
compensation.
compensation, my lord.
So take the decision immediately.
My lord, immediately, my lord. Question is this: the government valuer has to be go there and he will value it.
Do that.
And as per the terms of the lease, we shall give him.
What prevents you from doing that? Do
My
that
lord,
by
Your Lordship, Your Lordship, their offer was that whether we have intimated them.
appoint
They
a
have,
government valuer. He can do it within the course of this week and come back on Monday.
but
and
that,
pass.
Your Lordship, kindly it will take some time.
Why?
My lord,
Don't have a panel of valuers.
my lord, I have panel. We have panel of valuers. My lord, question is this: the money which will have to be paid. My lord, it as per the terms of the lease, it will be sent in auction after valuer, and the Your Lordship, kindly see the terms of the lease is there, but the procedure is mentioned in the lease deed. As per the
Because
lease deed, we shall
this
do.
is on the question of whether there can be a mutual resolution. If you want to give the pay the compensation, you give the
Sir,
rate.
compensation with regard to that, my lord, it has been said that valuer will be appointed. It is a base value, and then it will be sold in
Do that
auction.
within the course of this week. What is the difficulty?
My lord,
Just because it's government, it will take infinite time.
no, not infinite time. My lord, they have given us the.
What prevents a valuer? Appoint a valuer tomorrow. Let him
Who's-
go day after tomorrow.
My lord, yeah, we shall appoint a valuer. My lord, question of my lord,
The valuer takes some time to
valuer take some time. My lord, the building.
rise from his bed and go to brush his
Not
teeth and
that.
all this.
Your Lordship, give us 15
Appoint
days.
him, he'll go tomorrow.
Give us
Appoint
15
him
days.
tomorrow, he'll go day after
15
tomorrow.
days time. We shall appoint.
Why 15 days?
My lord, give for valuation.
Are you enjoying the interim order, Mr. We'll give you 2 months.
No, but appoint. Your Lordship, kindly say.
We'll give you 2 months time.
But not required. My lord, Your Lordship, kindly give a direction.
No, even if not required, we'll give you 2 months time. If you do it before that mentioned before us, we'll put it out of the list. And whenever your valuer is appointed and you take a call on this.
My lord, at least my lord, 15 days time calendar.
Why 2 months?
My lord,
Your
my lord, we have to
government
give-
valuer has to
No, my lord,
has
question.
to be of
No, my
is
lord,
of some
question of-
stature.
Question of
So,
these.
no, we'll give him 2 months.
My lord, question of this is this. We have to
Why
give.
2 weeks? We'll give you 2 months.
But Your Lordship, give some direction. My lord, we shall comply that. My lord, question. My lord,
We are directing you to do it within 2 months. We can give you more also. Up to the coming puja vacation, we can give you that time. No difficulty on our part. They're enjoying interim order. Let them enjoy. And let the government property still.
Well, it is 95. My lord, it is really lying my lord, unused. My lord,
Precisely. And you are so slack on this. 2 weeks time for a valuer to go and value. His job is to go and evaluate. Let him do it. How much time does it take? If he's a valuer, what the name?
My lord, I don't know whether, but say 7 days time valuation will be done. But thereafter, my lord, as per the terms of the lease, it will
The
be.
matter is at the stage of exploring possibilities of mutual settlement. Full stop. 2 alternative offers were given by the appellant. Full stop. First, comma, if the appellant the appellant is willing to match the prices at the as published in the official government website for the plot in question. Full stop. In the event the respondents are agreeable to give the land in lease to the appellant at such rates, comma, the appellant is agreeable to accept the same. Full stop. Next para. Secondly, comma, Learned senior counsel for the appellant has had, comma, on instruction, comma, offered that the litigation can be resolved if compensation is duly paid to the appellant for the investments and resources spent by the appellant on the plot of land by making construction, etc. For some next para, the respondents have in the meantime, comma, intimated that they are not willing to take the first option since there are other entrepreneurs willing to take the land, take the plot. Full stop. However, comma, on the second issue, comma, certain documents were sought by the respondents which have since been uploaded by the appellant. Full stop. Next para, learned counsel for the respondent WBSIDCL submits that a fortnight apostrophe time be given for the valuer of the for the government valuer to assess the value of the constructions and the other structures, comma, if any, made by the appellant on the plot in question, and to give an offer to the appellant as to the compensation payable by the respondent. For sub next para, as accordingly, comma, we adjourn the matter till February 9, 2026, comma, when it will be listed next under the same heading, full stop. In the meantime, comma, the respondent shall ensure that valuer assesses the construction and the structures on the plot and gives an offer to the appellant, comma, preferably within 3 weeks from date. For sub next para, upon receipt of such offer, comma, the appellant shall take a call as to whether to accept the same or not. For sub next para, it is made clear that the entire exercise as indicated above shall be concluded by the next returnable date. Full stop. In the event no consensus is reached by the parties on the next date, comma, we shall take up the matter for hearing on merits.
Lord, your lordship will kindly, my lord, see paragraph 12 of my lord's order because it is qualified in the meantime, the interim order, whether it requires to be extended. Paragraph 12.
Paragraph
12 of my lord's order, 23rd. And there was also, my lord, a liberty to give a hearing. That was also there, but not given.
Now its hearing stage is over because the valuation.
No, that was
If
integral to
required,
this order.
if required is লেখা আছে দেখুন।
If required.
ঠিক আছে, ছেড়ে দিন, আপনি দেবেন।
আচ্ছা, আরেকটা আর দুটো লাইন অ্যাড করে দাও। We make it clear that in the event, comma, for the purpose of mutual resolution, comma, the respondents deem it necessary to give a hearing to the appellant, comma, such hearing shall be given in the meantime. Push up next para. The respondent authorities shall not deal with the subject plot in favor of third parties till the end of February 2026 or until further order, whichever is earlier.
I'm great. I'm great.
Next. The mindset is problem. যেহেতু গভর্নমেন্ট সেহেতু রিপোর্টের কপিটা দেখুন অ্যাসেসমেন্ট থেকে রিপোর্টের কপিটা কই কি গো রিপোর্টের কপিটা কোথায়?
Well, in this matter, I am appearing on behalf of the respondent.
Your lordships, my lord, in this matter, we are appearing for the NIA, my lord. On the last occasion, your lordships were pleased to, my lord, submit a report, further progress report of the investigation, my lord. This is the, my lord, report we have, my lord, brought for your lordships' consideration, my lord.
Are there 2 copies there?
Yes, my lord. 2
একটু
copies.
খুলে দিন, সিল খুলে দিন, আমরা একটা অর্ডারে রেকর্ড করে নেবো যে আমাদের অর্ডার। What is the background of the case? Just give us.
Here, my lord, I have to read petition in this matter, my lord.
Give us a background. Don't argue the matter.
My lord, the two, my lord, persons, my lord, 2 students, ex-student of the school, were standing in, my lord, in a particular place, where, my lord, police was, my lord, to, my lord, dispense the mob. Police, my lord, reach and subsequently, police, my lord, fired the, my lord, bullet, and 2 persons have died. 2, my lord, students have died. And till date, my lord, they are, my lord, cascaded in, my lord, in the place, and till date we have not criminated on the, my lord, expectation that the second postmortem will be conducted. Since 2018, my lord, we have not, my lord, we are the father of the, my lord.
2 students?
Yes.
They have not been cremated?
No.
Where are they now?
They are, my lord, they have cascaded in, my lord, the body. We have preserved in, my lord, the.
For 2 years?
Since 2018. for the purpose of second postmortem, my lord. I mean, initially,
What was the writ petition for?
it was for investigations of the CBI.
It was not a habeas corpus. No
No.
question of habeas
No,
corpus.
the
So investigation you sought not by the police but by the
CBI,
CBI.
the trial court has, my lord, transferred the investigation to the NIA. Now NIA is, my lord, taking over, my lord, the investigation, and we are, my
Why
lord,
have you? Oh, the state has challenged.
state has challenged.
You have challenged.
Now, my lord, a series of order has been passed.
Here for the state.
And
What
it
is
was
the ground of your challenge to that?
Your ground of the challenge was, your lordship.
You cannot have any special preference for any particular.
And thereafter it was transferred also. It was transferred by an order dated.
It has already been transferred to the, my lord,
NIA.
Yes, yes, it has been transferred also on the last day's order. If your lordship sees, the only point for consideration remains was the report, filing the charges and all those.
Yes, can you give us the gist of the report? I mean,
Lord, we have given. Just
tell us,
this,
tell
my lord,
us.
it starts, my lord.
Because there is nothing so secret about this.
No, my lord.
So therefore we can discuss. I mean, and what
Yes,
is the difficulty? What is the
But,
stage
Lord,
of
this is,
investigation?
my lord, at the stage, my lord, some forensic report, my lord, is required, my lord. We have, my lord, given so many reminders, my lord, which is on record, my lord. And, my lord, after getting that report, my lord, the dimension of the investigation and further investigation of the case will be, my lord, changed, my lord. We have, my lord, approached the, my lord, FSL authority, CSL authority, and also forensic laboratory, my lord, for the purpose of, my lord, this is my injury, my lord. Two type, my lord, kindly have a look at, my lord, page to, paragraph 20, my lord. Your lordship may be kind enough to. Yes. Paragraph 20, my lord.
Yes, reports yet to be displayed.
The report regarding whether 3.303 plastic bullet can cause entry and exit wound. You know that because two persons were shot dead, my lord, and under what circumstance the police fired, my lord.
So you have detected you have got the weapons from which those were fired.
My lord, the difficulty is this, my lord, at the stage, my lord, when the state was investigating the case, my lord,
Later on.
nothing, my lord, relevant, my lord, things were recovered, my lord. That is the difficulty which when we took over the investigation after so many, at least, my lord, 3 years after, my lord, we did 6 years. After 6 years, my lord, if NIA, my lord, takes up investigation, when the preliminary duty was the police officer to recover all those documents, my lord. My lord,
How long will you take to file a fresh charge sheet?
my lord, we are
Or a
in
report
take
at
time.
least, a final report or a charge sheet, whatever.
My lord, we'll take, my lord, we'll find the.
Approximately, we cannot direct investigating agencies. This is not
That
a
is
civil suit.
true, my lord.
So you
But
will take your
we
time. We
are trying
appreciate
to
that.
explore, my lord, as early as possible, my lord. We are
What will be a reasonable period to
because
expect?
because it pinches, my lord. Pinches on the issue, my lord. We are dependent solely on the, my lord, the forensic laboratory report and also
These
the
forensic laboratories are in situated in Kolkata or where?
Gandhinagar. We have
Gandhinagar.
given reminders also. We can show to with your lordship.
So Gandhinagar has given any
No, my lord, nothing has been given to us. Report is pending.
Well, in
After
the
report
meantime,
we receive,
well,
we
in the
can assign,
meantime,
my lord, the, my lord, injury, how it is called, and whether it is police for the police firing or not, or any other.
Understood. But at least for the charge sheet, we can give you 2 months time to file a charge sheet at least. We'll put that expectation in our order.
Kindly, my lord, subject to your lordship's concern, my lord, kindly don't make any limit, my lord. But we immediately after the, my lord, report are received, my lord, we'll take.
Nothing remains in the appeal basically.
Basically.
Yes. Yes. So we are disposing of the appeal with the expectation that this will be. Because see, you have no say in this because you have already got your order from the trial court. We are not setting that aside. We are not disturbing it. So therefore, you don't have anything to say regarding this investigation. To satisfy our conscience, we have sought for this report basically. We'll keep this on record. And we'll expect that we put an expectation in our order that as soon as possible the NIA will, because the NIA is doing its job. We are satisfied on that. We are seeing the report. It's doing its job. And you have not challenged NIA. I mean, you sought for CBI, got NIA, never challenged.
There are two issues
We'll
pending.
dispose of the appeal, keep this on record, will not interfere with the impeachment.
Kelly, hear me for a moment, my lord.
Yes.
Here, my lord, in the postmortem report, you will also will find that the entry of bullet is there.
This is not a court-monitored investigation. There's a distinction between a court-monitored investigation and this. Although we are not much of a believer of court-monitored investigation because we don't know what we are doing when we monitor an investigation. We are not. We don't have the acumen.
No,
it's like a police officer adjudicating for us.
Only one thing.
Similar. If you take up the job of a police officer, we cannot do it. So they are doing their job. If there was something gross which showed that yes, this is not being done properly, they have given details, and we'll keep this on record. And we are a court of record. This will be on record.
Well, 1.5 years has already been lapsed. after the.
But you have not challenged NIA.
No, they are not investigating nothing.
You have not preferred any
but that
challenge.
doesn't
You are
tell
at
me
liberty to take up that challenge before an
No,
applicant.
I am not challenging. I am saying that let the NIA, my lord, do their
appeal.
investigation.
Nothing remains in the appeal.
And my lord, another thing, my lord, there was the order for my lord, compensation to the my lord, victims, but that has also not been paid.
Take out an implementation application before the writ court.
Since my lord,
The court directed that.
It could directed.
But liabilities have not yet been fixed. Who will give you the compensation?
The state. There is a specific order to pay the compensation to
If
the
that is
state.
not complied with, take out an implementation application before the writ court.
But the earlier, my lord,
Take out an implementation application. If the state is not responsible, why should if the NIA ultimately finds that the state is not responsible? I mean, we cannot prejudge things. State is sometimes the villain, not always the villain. There are other villains also.
No, I have not.
So we cannot proceed on a presumption that rich men are bad, poor men are good, investigating agencies are corrupt, judges are corrupt. These cannot be presumptions. Let us see how this investigation plays out. I mean, let us wait for that. Nothing remains in the appeal actually. We are not monitoring the investigation. This is for our conscience, and we are satisfied that it's going on as far as our limited knowledge about investigations go, which is very limited, we tell you, as courts of law. But it appears we'll keep this on record so that it can be accessed by any party at any point of time. We'll take out certified copies. We'll make this a part of the record. We'll not keep it secret. So that is the best we can do for you, your clients.
Only, my lord, if my lord, they do, my lord, the second, my lord, postmortem, because we are, my lord, waiting since
If you have any
2018.
difficulty regarding the investigation, there are other forums for you to approach. There are criminal forums for you to approach. There are writ court forums for you to approach. You can do that if there is any difficulty on your part regarding this investigation. But this is the state's appeal they challenged. We are not interfering because it has proceeded sufficiently. So we'll not upset the order and give it to the police authorities. And it's obvious we also feel that, I mean, since there are allegations against the police, therefore it should go to an independent agency like the NIA, which we are satisfied. So the genesis of the present appeal is an order passed by a writ court on the application of the private respondents, who are the unfortunate parents of two deceased students. Full stop. The incident which gave rise to the writ petition was a ruckus, in which the said two students met their demise. Full stop. The writ petitioners sought investigation by an independent agency, which was granted by the writ court by way of handing over the investigation from the state police authorities to the NIA. Full stop. Next para. The NIA, within bracket National Investigation Agency, was directed by us to file a report as to the progress of the investigation in the present appeal, which has been preferred by the state against the order of the learned single judge. Full stop. Next para. Insofar as the progress report is concerned, which is given to us in a sealed cover, we direct the seal to be opened and peruse the reports. Full stop. From a perusal of the said report, we are sufficiently satisfied that substantial progress has been made by the NIA, particularly keeping in view that they were handed over the charge of the investigation at a belated stage, when some of the evidence might have been lost. Full stop. Next para. In any event, in order to enable all concerned to have access to the reports at future points of time, if necessary, we make the reports a part of the record and make it clear that it will be open to any interested party to obtain certified copies of the report from the records of this court. Full stop. Next para. However, at this stage, we are not recording the particulars of the stage of investigation, since it might have a detrimental effect on the ongoing investigation. Full stop. Next para. Insofar as the merits of the appeal are concerned, since the National Investigation Agency has already progressed sufficiently into the investigation after being handed over the charge of the same, we are not inclined to interfere with the impugned order. Next para. Moreover, we cannot lose sight of the fact that serious allegations have been leveled by the writ petitioner stroke present respondents against the police authorities, comma, who are under the direct supervision of the state government, and as such, comma, it would not be fair, comma, in the interest of justice, comma, even without casting any aspersion on the police, comma, to retain the investigation with the self-same authorities against whom charges have been leveled by the writ petitioners. For the next para, in such view of the matter, MAT 924 of 2023 along with Can 1 of 2023 are disposed of without interfering with the impugned order and keeping the report filed by the National Investigation Agency today on record. For the next para, we express hope and trust, comma, going by the progress made till date in the investigation, comma, that the investigation shall be concluded within a reasonable time and a charge sheet shall be filed. Not a charge.
Report in
And
final
a charge sheet or a final report.
Report in final form.
Charge sheet or a final report, comma, whichever is applicable, comma, shall be filed by the NIA at the earliest before the appropriate court stroke forum.
Only, my lord, I beseech your lordship to consider one thing, my lord.
No orders to
At this stage, my lord, the report may not be, my lord, kept public, my lord, be given to public, my lord, because, my lord, certain indications are there, my lord, and the further investigation going on, my lord. That may entail the further investigation because some indications are there. We have removed the names. That is all right, my lord. But in such a case, my lord, their interest will be prejudiced. So, my lord, at this stage, my lord, kindly, my lord, don't give that access.
So we'll put a writer যেখানে বলছি certified copy apply করতে পারে করতে পারে
after filing of the charge sheet, my lord, they can do all of this
certified
for their interest or the
যেখানে
victim's
বলছি
interest.
certified copy apply করতে পারে সেখানে after filing of the charge
My
sheet.
lord, deep lord.
Thank you. You're right.
May I get a copy or my lord?
No.
But at this stage, no.
Great.
Deep lord.
Thank you. We will be entitled to Meghnad, we will be entitled to obtain a certified copy যেখানে বলেছি না after the charge sheet, after the filing of the charge sheet stroke final report as applicable যেখানে আছে দরকার হলে বোল্ড করে দিলে আমরা রিপোর্টটা স্টেপল করে দেওয়াই ভালো দুটো রিপোর্ট Yes, Mr. Right.
Lord, I am for the petitioner.
To appear for the state.
State.
The gist of the case before opening paper.
Yes.
This is a case relating to
You can take your seat, Mr. Rai. Yes. No, Mr. Rai, don't take your seat. And you also can take your seat. Yes.
This is relating to appointment in a Group D post in a high school. What happened, my lord? There was a prior permission for filling up a Group D post. Initially, it was through exchange on said candidates. Then subsequently, my lord, I moved the Honorable Court, taking into case of union exercise, my lord, High Court directed that you can apply for. Therefore, I participated. But after participation, there was a recruitment process, selection committee formed, all these things. Then the panel was prepared. I topped the panel. Then it requires approval of the DI.
This is a Group D post in
a high school. Then panel requires approval of the DI. It was sent to the DI for its approval. Then DI, on giving certain reason, disapproved the panel. Disapproved. I challenged that. Simultaneously, the school management also moved a writ, challenging the decision of the DI. Both the matters were heard analogously for some time. Ultimately, for any reason, the school did not proceed with the matter. It was dismissed for all. My matter was it was solely rejected on a ground that since the decision has been taken, I cannot challenge it.
Let us
On
see
mental liberty ground.
Let us see the impugned order first.
That is the impugned order.
Let us see the impugned order, then we'll.
Impugned order, my lord, page 62.
Yes.
Court's order. Court's order is the
No,
last
court's order.
Yes, court's order.
Not the,
yes,
court's order.
Starting from page 69.
Yes.
71 is the
71
order.
is the yes.
May I read, my lord?
Please.
This is the
If the facts are what you said, then we can start with the decision portion also for
Yes,
the
yes,
timing.
yes.
Then, if necessary, we'll come back.
Yes.
Yes. Para 21, page 76.
Decision. After considering the rival contentions of the parties upon perusal of the materials on record, this court proceeds to deal with the point of maintainability of the petition. The law is settled that a candidate merely by virtue of being empaneled does not acquire any right or vested right to challenge the selection process or the panel so long the panel is not approved and the candidate does not receive the appointment. On the basis of the said golden rule, the writ petition needs to be looked into. In this case, the petitioner was merely an empaneled candidate. The panel was not approved but was rejected. Thus, no right had accrued in favor of the petitioner. The first order in this petition dated August 26, 2008 merely directed the school authority to go for a wide publication before holding recruitment process, and an observation was made that if the petitioner was otherwise qualified, he could participate in the selection process. This definitely cannot create any right or vested right in favor of the petitioner to challenge the selection process merely being empaneled. The next order in the second writ petition dated August 6, 2010 merely directed the DI to communicate the fate of the panel on which he was sitting idle to the school authority. The question of recognition of any right of the petitioner did not arise in the said order. Therefore, none of these orders created any right in favor of the petitioner in manner. In the matter of Kaushik Maulik Supra, the relevant panel was published and a lesser rank holder candidate superseded a higher rank holder candidate. In the light of such fact situation, the writ petition was held to be maintainable.
Mr. Rai, you have read it. East Coast Railway is most apt in your case, probably. Because there the no valid reason was assigned and the examination itself was cancelled. Here the panel was cancelled.
I personally feel, Millard, subject to Millard, don't take it all, is entirely wrong approach. Why I tell you? It's a question of, here is a case, panel not approved. Had it been a case, a panel approved, I say tight over the matter, it was not implemented, I could have understood. Here is a case, a decision disapproving a panel.
But Mr. Wright, satisfy us on this. The learned single judge has held, because if this is one of the plausible views, we cannot interfere in an intra-court appeal. You know that. Now, why shouldn't it be? Why shouldn't we hold it to be correct that you don't have any locus standi in the sense that mere impanelment that does not give you a right of any sort to get an appointment?
No, panel, I fully agree. But facts remain here, panel is not approved by taking a decision. Had it been a case, a panel was approved, it kept for some time, vacancy was not there, all these things are there, then this question could arise.
So what was your ground of challenge to
Various grounds were there. I challenged the decision. He has given certain reasons. Court had not looked into. He has given certain reason for this reason, panel cannot be approved. I say it is not correct. It is not contrary to record. That this question has court has not gone into. Court say, yes, I have challenged a decision. Had it been a case, the panel was approved, I waited for some time of the panel expert, I could have understood. Here is a panel got approval when DI sanctioned it. Unless DI approve it, panel does not take its life. Life of the panel comes when a panel approved by the DI.
Yes.
Then here is a question. Selection committee took a decision. It was referred to the DI. DI on certain grounds, which I have challenged.
What were the general grounds? Just give us an idea, Mr. Rai.
All these grounds, my lord, according to me, I have para-wise I have quoted. All these grounds is not actually tenable. If lordship wants, my lord, I can
just
show
one or two grounds. Just show us the nature of your challenge.
According to them,
yes,
there was no selection committee. I showed there is a selection committee. 6 marks was for oral interview. 6 marks was not allotted. I say on record, everything is covered.
Yes, what do you say? Mr. Rai, apart from these judgments which you already cited, do you want to say?
Why I cited this email? Actually, when the matter was taken up 2 to 3 days, this question of panel comes into picture. When question of panel comes into picture, I have to show it. Then I find Millard with great respect. Subsequently, when delivering judgment, court say, I say, my lord, a decision, I am challenging a decision. Had it been I am empaneled, if I could have empaneled, then question of expiry of panel does arise.
But ultimately, this relates to your locus standi can only be derived from your right to get appointed. Because
yes,
so if that be so, if you don't have a right, locus standi regarding that, then this is a derivative locus standi in a sense.
No, what I say, my lord.
Probably I could not clarify myself.
Not,
I'm just trying to say that ultimately your right. I mean, you want to get an employment.
Yes.
So if you don't have a right to get impaneled,
yes.
I mean, this does not confer you a right.
Yes.
Sorry, empanelment does not give you a right to get employed. Then do you have a derivative locus standi? I mean, it's more remote. I mean,
no,
that
it is not more remote, subject to class.
Yes,
Why I
yes,
tell you?
yes. We all want an answer.
Supposing, my lord,
Yes.
my lord, number of things my lord has seen that appointments are given after 4 years, 5 years, 10 years.
Yes.
Here is a case, I am a participant. I participated.
And you are the successful candidate.
I am the successful. Selection committee is the authority, they can decide this. They have decided in a manner.
So you say your right to get into the pool
Yes.
for being selected is being affected.
Yes. Had it been a case, the DI thought that panel is approved. Then question is now.
Then you would be eligible for, you would be the best candidate. And
Then question of panel does arise. But here is a case where a decision taken by the DI that I am not approving the panel. Then the question of panel does not arise.
Give us half a second. Sir, let us hear this state once. Yes.
Only thing was certain facts, it will take your lordship to some help, my lord.
Yes.
Page 46, prior permission. Just
yes,
how the things has gone. Page 46. This is a prior permission. Page 46. When a recruitment process, it starts from a prior permission.
Yes.
This is given by the DI. Then, my lord, page 47.
Yes.
I submitted to your lordship that how I came. It is by court's order. Justice S.K. Gupta passed an order.
These were discussed by in the impugn order also.
Yes. There. Then just my lord, is relevant, page 61.
Yes.
A question came that by this time the School Service Commission that has come into force. Then why your candidature will be considered?
Yes.
Then I moved this honorable court because after sending the panel, it was kept withheld for certain period of time. Then Honorable Justice Dipankar Datta made it clear, the last paragraph, since prior permission was issued on 7/27/5/2008, amendments effected in the West Bengal School Service Commission Act shall not be constituted as a bar for approval panel. Before that, having regard to the parties, the court finds no reason to keep the writ petition pending. The same stand disposed of with the direction upon the direct district inspector to convey his decision on the panel in accordance with law. Therefore, without taking into consideration the implication of School Service Commission. Therefore, my lord, this is the basis based on which the impugn decision by the DI passed. Court has also made it clear since the school before coming into force of School Service Commission has come into force, DI has to take a decision. Then this decision is pursuant to court's order. Therefore, my lord, DI has taken decision.
But DI has taken the decision.
I am challenging that decision. I have a right to challenge it. If I am not satisfied with the decision of a DI, where do I go? Then I am formless. DI has passed a decision, good, bad, indifferent. He could have passed the decision in my favor. Now he has taken decision that this is the reason for which I cannot approve the panel. This is the DI's department. I have challenged the decision. The question of panel. Panel got approved when the DI sanctioned it. It's a pre-stage.
So you are neither learned single judge held a candidate merely by virtue of being impaneled does not acquire any right or vested right to challenge the selection process or the panel. You are challenging neither.
I am
You are
challenging.
relying on the panel.
I am challenging on the decision of the DI. DI has disapproved the panel prepared by the managing committee.
Yes.
Subject to correction, my lord, that forumless, this concept is not applicable since it doesn't mean that a decision has to come someone's favor, then he is in the right forum. Page 73, we are on the sole ground that the petitioner, merely because of his empanelment, cannot does not accrue any right in his favor. Paragraph 19 is our submission being recorded. Page 73. Paragraph 19 of the impugned order passed by this honorable court.
Paragraph 19, not at page 73.
73 in my brief, it is 70.
Paragraph 19.
Paragraph 19 of the impugned order.
Please place it. Yes.
Yes. This learned state council led by Mr. Sujan, the learned additional appearing for the respondent 123 submits that in facts of this case, the writ petition was merely an impaneled candidate under the panel prepared by the managing committee of the school. The panel was sent for approval before the DI, but for certain valid reasons, as would be evident from its decision dated January 31, 2011, annexure to this writ petition, the panel was rejected. Because until a panel is approved, an appointment letter is issued, no candidate has any right to challenge a panel or the selection process or the rejection of the panel as in the split case. My lord, the DI, apart from this locus, my lord point, the DI has taken a decision pursuant to the honorable court's order in accordance with law. He has found what he found, my lord, as page 46. The irregularity, rather the illegality, what he has come across during this process of taking decision on this panel is reflected from, it is very concise. May I just place the report?
Because the learned single judge has not gone into that. We cannot go into that at this stage.
Yes.
Either in his favor or in your favor.
Yes. We say, my
You
lord,
only are considering because the
locus, because my
only
lord,
locus.
yes,
Only.
locus, because this panel, the DI has found the until the school make good of the panel, the defects, how the petitioner can make a defect. He has entirely detected the illegality.
No, but here we are not on the panel.
Cannot,
we are on the locus standi.
Yes.
This person is not seeking at the present juncture. He is not seeking an appointment.
Yes.
He's not seeking an appointment. He may not have a vested right to get an appointment even if he's on the panel.
No, he's seeking his prayer.
But the disapproval of the panel.
Yes.
Now that, because he was the top candidate, isn't his right directly affected because he was the top candidate? If that is set aside, that the approval is not granted, rather the panel is not approved. Doesn't his right, aren't his rights directly affected? I mean, regarding locus standi, now writ petition locus standi is being widened.
Yes,
broadened much.
Mere empanelment, it is, my lord.
Not a right to get an appointment. If he asks for an appointment, we could understand. But he says that the panel should remain, and on the basis of that,
the panel, that result would be, my lord, same, that he will have to be given appointment. Although there is a illegality in the panel that been detected by the DI.
No, but he's challenging that.
Yes.
If he wins, if he gets success in the writ petition,
Yes.
then the disapproval is set aside and it will be approved.
Yes.
If that be approved, then it will be directly, I mean, he does not have a vested right to get an appointment. But he has a vested right to
it is not a the
defend
invention.
his coming out successful in the panel.
Yes. As because he is coming up successful, he stopped. And
That
what
goes, his right goes. This is all about opportunity. His opportunity to get a chance for appointment.
Yes. Indirectly, he will be given, the state has to give him the appointment.
Have you got any decision to show that this right is not accrued?
As of now, today we have not come up, but
we don't see that you cited any decision either before the learned trial judge, learned single judge.
Because during the hearing, it was we could satisfy His Lordship, that the same panel
No,
mere
certain
impanel-
judgments were cited by them. So you both of you came prepared. And how do you deal with this? Because learned single judge deals with, please come to paragraph 26 of the
Fine.
East Coast. Their examination was cancelled.
Yes.
One of the examinees was held to have locus standi
Yes.
by writ petition. So why shouldn't that principle apply here? 26 East Coast.
Yes.
The examination was cancelled and no reason or valid reason, no valid and or valid reason was assigned for such cancellation.
Yes. But here,
No valid reason was assigned.
yes, here decision was taken that examination, that selection process completed. This decision of the DI as regards the panel was pending. That has been in accordance with law, has been directed, and DI by citing reasons he has rejected.
প্রিন্সিপালটা যেটা বলছে সেটা হচ্ছে এটা ফলো হচ্ছে অ্যাপয়েন্টমেন্ট করে পেনশন ক্যান্ডিডেট যদি চাকরি পেত যদি সেটা সে ধরে যেতে চান সেটাই গায়ে লাগছে সেটাই তো কথাটা কোনো চ্যালেঞ্জ ইউরিজা সাইবেরিয়া মিডিয়াম
Yes, yes. Anything else?
Yes, my lord, and this apparently, my lord, the DI's decision, my lord, although, my lord, we had no.
You cannot go into that.
Yes.
You cannot go into.
So it is directly, my lord, this disapproval means now the DI has to, mandate has to be issued to the DI to approve the panel. Then is directly getting appointment. It is nowhere, my lord. It is.
Let us pass. The present appeal has been preferred against an order whereby the learned single judge has dismissed the writ petition preferred by the appellant on the ground of lack of locus standi. Which of next para, the brief backdrop is that the appellant was the appellant applied for employment in a group D post in a high school. Full stop. Next para. Initially, there was a checkered history, comma, which culminated in an order dated August 6, 2010, passed in WP 16413 within bracket W of 2010, comma, where a learned single judge of this court had observed that the district inspector was to convey his decision on the panel in accordance with law to the managing committee of the school as the petitioner within 30 days from date of receipt of a copy of this order, of the said order, full stop. It was further observed that since prior permission was issued on May 27, 2008, comma, the amendments effected in the West Bengal School Service Commission Act 1997 with effect from 14.1.2009 shall not be construed as a bar for approving the panel. Full stop. Thus, comma, the present appellant was permitted to be considered for empanelment irrespective of the subsequent amendments effected in the 1997 Act. Full stop. Next para. Thereafter, comma, the petitioner secured the top position in the panel which was sent for approval to the district inspector. Full stop. However, comma, the district inspector, comma, on certain grounds, comma, disapproved the panel, comma, challenging which the writ petition was filed. Full stop. Next para. The learned single judge, comma, upon consideration of the arguments of the parties, comma, was pleased to observe that the law is well settled that a candidate, comma, merely by virtue of being empaneled, comma, does not acquire any right or vested right to challenge the selection process or the panel so long the panel is not approved and the candidate does not receive the appointment. Push up. Next para. While holding so, the learned single judge took into consideration several judgments cited on behalf of the parties. Pushed up. Next para. Learned counsel appearing for the appellant contends that despite the position of law being that merely by empanelment, no vested right of appointment accrues in favor of the successful panelist, that does not mean that a candidate who topped the panel cannot even challenge the disapproval of such panel by the district inspector. Next para, it is submitted that since the rights of the petition appellant are directly affected by the impugned order of the district inspector, such infraction of the petitioner's right gave a conferred locus standi on the petitioner to challenge such disapproval. Next para. Learned counsel further submits that the petitioner stroke appellant has a good case on merits. However, we do not enter into such arguments at this stage, since the impugned order was passed only on the ground of locus standi. So next para, learned counsel appearing for the state controverts the contentions of the appellant and submits that by virtue of the challenge thrown against the disapproval of the empanelment, the petitioner, indirectly, is seeking appointment, which right is not available merely by virtue of empanelment. It is argued that the fallout of the petitioner succeeding in the challenge against the disapproval of the panel, if at all, would be that the panel would have to be approved, and as a logical corollary, the writ petitioner stroke appellant would be getting the appointment. Since it is well settled that mere empanelment does not confer any right of appointment, it is argued that the writ petitioner stroke appellant cannot get indirectly what he cannot get directly. Next para, it is further submitted that the district inspector gave a reasoned order and disapproved the panel. Since the challenge preferred to the same by the school itself was subsequently not proceeded with, the petitioner, in his individual capacity, did not have any locus standi to challenge the disapproval. Next para, upon considering the arguments of the parties, we find that there is a distinction between a vested right not being conferred on a person who has been impaneled, to get the appointment, and the right of the successful panelist to challenge the disapproval of the panel itself. Next para, the outcome of the disapproval of the panel, which was topped by the topped by the writ petitioner stroke appellant, would be that the writ petitioner stroke appellant would lose the very opportunity to get an appointment. Next para, since the approval of the panel or the disapproval of the same directly affects the said opportunity of the writ petitioner stroke appellant, this court is of the opinion that the rights of the writ petitioner stroke appellant were directly affected by the approval, by the disapproval. Next para, this case is a typical scenario where, although the writ petitioner stroke appellant might have a grievance that the disapproval of the panel was unlawful, thereby conferring a right on the writ petitioner stroke appellant, the successful panelist, to challenge the same, such right would not fructify, thereby now which would be hit by the principle ubi jus ibi remedium. Full stop. Next para. Accordingly, comma, we feel that the judgment of the Honorable Supreme Court in the matter of East Coast Railway and another versus Mahadev Apparao and others, reported at 2010 7 SCC 678, would be apt. Full stop. In the said case, comma, the examination was cancelled and no reason and stroke or valid reason was assigned for such cancellation, comma, under which circumstances it was held that the writ petition by a candidate was held to be maintainable. Full stop. Next para. Although the learned single judge, comma, with utmost respect, comma, distinguished the same judgments, comma, the said judgment, the ratio of the said judgment is applicable to the present case as well. Full stop. It is to be noted that in East Coast Supra, comma, the Supreme Court had observed that even if the examination was cancelled not for valid reasons, comma, the writ petition, a candidate would have the locus standi to maintain a writ petition. Full stop. Next para. Similarly, comma, in the present case, comma, the panel, comma, which was stopped by the writ petitioner stroke appellant, comma, was disapproved by the impugned order of the district inspector, comma, which directly and adversely affected the rights of the writ petitioner, comma, thereby conferring locus standi on the writ petitioner stroke appellant to challenge the same. Full stop. It is made clear that such a challenge, comma, even if successful, comma, would not automatically translate into conferment of a vested right on the petitioner to get an appointment, but would only stop at the stage of approval of the panel, comma, which would subsequently be followed up by the process of appointment. For sub next para, in view of the above considerations, comma, we are of the opinion that the learned single judge erred in law in dismissing the writ petition on the ground that the writ petitioner stroke appellant does not have locus standi. Full stop. Accordingly, MAT 517 of 2024 is allowed on contest, thereby setting aside the impugned judgment dated February 8, 2024, passed in WPA 13385 of 2011, and remanding the matter to the learned single judge for the purpose of re-adjudication on merits upon giving opportunity of hearing to both sides. Full stop. Can 1 of 2025 is accordingly disposed of as well, no address to cost.
Lord,
Urgency.
only one
Yes.
submission I think, my lord, this is a matter of 2011. My lord,
Single
only one, sir. If your lordship passes two things, my lord, from here a direction for affidavit, and also give me leave so that I can approach. Because otherwise, my lord, if
leave to approach
the single judge for expeditious disposal, these two, my lord, 11 matters. If he gets anything, nothing will remain. Already 14 years have passed. That is my prayer to you.
Liberties
and for the direction for affidavit. This can be done, my lord. To expedite the matter, my lord.
তাহলে যেখানে নো অর্ডার্স টু কস্ট বললাম তার আগে হবে, ঠিক, যেখানে ডিসপোজ অফ করে দিলাম তারপরে। ভেরি গুড। The respondents in the writ petition shall file their respective affidavits in opposition to the writ petition within 3 weeks from date before the learned single judge. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. Liberty is given to the present appellant to approach the writ court, comma, in view of the long pendency of the matter, comma, seeking expeditious hearing of the writ petition. Group D. So this much is yes. নামটা your appearance. Yes, it is. Yes. Sweet. কবে আছে ডেটটা? কখন আছে? কালকে 3:30। Yes, please. Yes. The rest of the day.
No, the facts are admitted. There is no controversy about the facts. The question is whether in violation of the rules, the transfer order can be maintained.
Is that?
And whether the minister has got any authority to recommend the case of transfer, and on the basis of the recommendation of the minister, the Commissioner of School Education can issue the order of transfer. This is the issue. So for the other aspect is concerns, there is the not making application as per the transfer rule, it is admitted position. Now, my lord, Mr. Mojumdar, at this appellate stage, raised a point regarding the order of transfer under Rule 10C. Rule 10C incorporated in the year of 2017, 3rd April. And same was pending before the Supreme Court. And ultimately, it has been affirmed by the Supreme Court that it is. Now, that is the completely different case. There is without any applications, the Rule 10C provides the Secretary of the School Education Department can issue the order of the transfer for the interest of the students or the institute from A place to B place, B place to C place, C place to D place. That
Interest of public, but this is on their prayer.
there. Now, here, my lord, what has happened? This, I should say, the glorious headmistress. She was transferred thrice. And in the thrice, my lord, the school, the public, they are furious and they have been, the headmistress was prevented from attending the schools. Sometimes the chaos, sometimes the police interventions. These are all 3-4 schools. These are the happening. Same things. And all time, when it was happened from A school to B school, B to C schools, immediately order of the transfer was issued. And from A school to B, when there is a problem in B, then C, while there is a problem in C, in D. But I have never seen such a powerful headmistress that the one after another, the order of the transfer order was issued. Now, very interesting thing, when she was transferred from the A school to B, there was a challenge in the repetitions by filing that particular schools and Joka Brotuchari schools. And the single judge passed an order of stay. During the pendency of the stay order, no steps has been taken for vacation or variation of the stay order. No step has been taken to prefer an appeal against that order. That is still pending. It has not been finally disposed. Until further order, the stay order was granted. During the pendency of the application, without taking any leave, that headmistress again transferred to another schools. Then, there is a problem in that schools. Then he made an application to the principal secretary. Kindly issue the order of the transfer. There is a problem. Facing the problem. There is an public agitations. I contacted the local police station. Police came and rescued me. Kindly transfer. Then order of the transfer was issued to the Kamala Girls. But the Kamala Girls schools is a very reputed schools in the South Calcutta. When we have no personal
we are thinking about that. How are you affected? I mean,
yes, that
is also thinking.
When, my lord, this type of headmistress, when there is a clear violation of the rules and political intervention was there, managing committee searched out the previous history of that candidates, and my lord, thereafter we filed a writ petitions. Now, writ petition initially it was entertained, order of the stay was granted, thereafter disposed of, thereafter consideration order was made, thereafter my lord, the further writ petitions ultimately.
No, this was your writ petition. This
yes,
is from you. So, what is your local stand? I mean,
because
how is the school affected?
Managing committee, the managing committee has every right to. One of the judgment your lords is delivered that the one particular gentleman assistant headmaster He filed a writ petition in Poshun Sundar Tarafdar. I argued before your lordships. And your lordships, without going into the merit of the case, only the question was the how you are aggrieved. What is your locus? And your lordships' categorical observation, had it been a guardians, had it been a students, then you have a locus.
So you are pointing out
that we are the managing committee.
The illegality.
Yes. And we are the managing committee. Here the managing committee. And in the transfer applications, unless the no objection is given, you cannot make an application before the authority. It is then the rules. That you have to obtain a no objection certificate from the school authority.
It was not taken in it.
No, nothing. The managing committee was kept into dark. All managing committee. He is directly making an application to the principal secretary. And minister in charge immediately, my lord, the one after another is making recommendation to the board. And board is acting. And board is issuing a...
The board will come back in 10%. Yes, sir.
So now, my lord,
Let us.
what is the illegality in the judgment? Because the court considered the entire rules and the two division bench judgment that in the identical issue. And my lord, after considering the entire matter, court delivered the judgments by holding that this order of the transfer is not according to law. And surprising thing, there was no stay till today. My lord, the court directed to join that Kankuli schools.
Not joined.
Not joined till today. And their demand is that they pay the salary because she's habituated that the paying salary from sitting residents, well, it is being blessed by the superior authority and is always in habit to receive the salary from your residents. The court directed you join there, but she didn't join. Now your lordships kindly see
paid the cost of 50,000. Cost was directed.
Nothing has been paid. No stay, no joining, no payment, nothing. Now
yes.
Order of the transfer. The compilation they have submitted, if your lordships kindly takes up.
Thank you. ఇదంతా ఇదం Uttala.
Compilation these.
Yes, this.
Lordship got it.
Melan brother is.
It is the word.
ইরম একটা আছে
Compilation of convenience brief.
Yes.
Lordship got it?
Got it.
Now, my lord, dear lordships, kindly come page 15.
Yes.
This is an application for transfer. Addressed to the principal secretary.
This is the last application to your school.
Yes, yes. This is the application from in Kankuli schools from where he was transferred to my schools. Then, my lord, the prayer for transfer on special ground of Srimati Madhumita Rai, headmistress of Kankuli Girls High School, such and such, addressed to the principal secretary. I joined the Kankuli Girls High School as headmistress on 18 November 2014, and it was then a government-aided school. After my joining, this school was converted into a government-sponsored school. Accordingly, new managing committee was constituted on such and such. Since then, the conformity with the decision of the school management committee, the school was being run with the mission of improving its academic standard and discipline. But on 28/2015 at around 1:30 p.m., a large number of outsiders gathered around my office chamber. They started hurling abusive language at me and planting brickbats inside my office chamber. Some of the outsiders ransacked in the office chamber, broke and table glass and window panes and disconnected the telephone connection. I immediately apprised the officer in charge, Rabindranagar Police Station, of the situation over personal mobile phone. The deputy superintendent of the police and the officer in charge, Rabindranagar Police Station, arrived with the police force, rescued me. I have been on leave since, as they said, unruly outsiders threatened me that they would again assault me if I attend the school. In view of the above, my earnest appeal is that I may kindly be transferred on special ground to another higher secondary schools in Kolkata. Considering in that present situation, I shall not be able to work in the Kankuli Girls High School as my security will be at stake there. Well, this is the letter addressed to the principal secretary on the special ground. There is no such provisions for making applications, special ground transfer to the principal secretary. Now, my love, what is the date of the application? 5th January 2016. Where the incident happened? On 20th August 2015. 20th August 2015, the incident happened. Paragraph 3, it has been mentioned. And my lord, he is making an application for general transfer
There must have been some police complaint by her on this. Police
No,
complaint.
there is no FIR, only GD entry.
Did
There
not
is no
culminate in an FIR.
No, nothing. No FIR. Now, your lordships kindly see the rules. Transfer rule, page 16, 16. General transfer on special ground. An incumbent belonging to the following categories may apply for transfer on any of the special ground, namely, they are happening upon the clause B, A, B. Any woman teachers or non-teaching staff whose husband died prematurely and divorced and is a victim of crime.
So they're trying to invoke victim of crime.
Well, they are trying to impress that they is the victim of crime. Now, rule 3. In respect of the special ground victim of crime mentioned in the clause B, sub-rule E, the application may be considered whether FIR has been lodged and cause has been instituted. Case has been instituted. Nothing.
That is what the first question is.
FIR was lodged. No case has been instituted. And he may not be treated as a victim of the crime. Office was ransacked. Every day this is happening in our country. The office is being ransaked. That doesn't mean that he is the victim of crime. And what is the rules? Eligibility of the general transfer. Procedure has been mentioned in rule 6. 6.4, your lordships kindly. The application shall be submitted to the concerned district inspector of schools through the head of the institution or the secretary of the managing committee or the administrator, as the case may be, of the concerned school. In case online application, extract application so filed shall be printed and the same shall be submitted to the concerned district inspector of school secondary education through the head of the institution or the secretary of the managing committee of the administrator, as the case may be, of the concerned schools. So rule 6 has been prescribed for a procedure for filing the applications, and rule 6.4 categorically mentioned the application shall be submitted to the DI with the permission and with the managing committee. Now, my lord, the rule 7, if your lordships kindly text double, page 23A. Procedure for general transfer on special ground under rule 4.1A and rule 4.1B. For 1B and 7 procedure has been laid down. The teacher shall submit the application with sufficient documents for consideration of the managing committee in connection with the transfer on medical ground. Now, the managing committee may, after examination of the prayer, after receiving views of the medical, that is another. The school education department may, after proper examination, recommend the prayer to the West Bengal School Service Commission. In case of the district reallocation of the department shall cause and necessary inquiry in the vacancy report. That is only medical ground. Now, my lord, admittedly, the no application was filed before the school authority and no permission was taken from the school authority. Any of the school authority before, my lord, in a Kankuli and others, and Joka Brotuchari, from where Joka Brotuchari, he has been transferred to the Kankuli, and from Kankuli to the Kamala girls, but nothing, no application for any other reason has been submitted before the managing committee of the schools. They are directly making an application to the principal secretary. There is no such provisions and rules. And 10C, if they, my lord, Mr. Mojumdar was submitted 10C, my humble submission, the 10C did not see the light of the day because the application was made on 5/1/2016 and 10C came into force and 3rd April 2017. to show question of applicability 10C. Moreover, they have not taken that plea before the trial court or the appeal court, and even in the memorandum of appeal, they have not taken the plea that the 10C. Nothing. This is the argument. It was advanced from the bar. So, show my lord, humble submission would be your lordships kindly don't take into considerations that the applicability of the 10C. Now, your lordships kindly see the when the writ petitioner, the Madhumita writ petitioner in the second page 6, if your lordships kindly turn, when in Joka Botuchari she was appointed as a headmistress. Then, my lord, the managing committee filed a writ petition before this court that schools in Joka Botuchari, they have disclosed this. The order of the transfer was challenged by that management. My lord, page 6, if you lord, the writ petition is directed against the order passed by the respondent number 3 under memo number such and such. By virtue of the impugned order, the respondent number 3 directed the petitioner school to allow the respondent number 8 to assume the charge of the office of the headmistress of the school by way of transfer from previous school, namely Sahuchori Bihari Vidyapit district, Sahuchori. Initially, my lord, he is the Sahuchori, thereafter transferred. The above order is passed on an order passed by the respondent number 2 under the memo number such and such. The prima facie consideration of the above order same is quoted below. The order is not a reading, my lord. The sit anchor of the above order of the respondent number 2 is an order passed by the Joint Secretary to the Government of West Bengal School Education Department, Secondary Branch. Prima facie consideration of the above order, the same is quoted below. Information received from the district magistrate Sahuchori that Madhumati Rai, headmistress of the Sahuchori Bihari Vidyapit, Sahuchori was prevented from attending the schools to render her service as a headmistress. The matter was inquired and verified. On the basis of the report of the service was temporarily withdrawn from the school. Hence, under the above stated fact, the governor is pleased to allow the transfer from the previous schools and to place the service of the Joka Botuchari Vidyashram Girls School, South 24 and the period from 5/4/2013 till her date of joining the post of administration in the new school may be considered as on duty on receiving the report from the DI South 24. This commission of the School Education Department will issue necessary order after observing the formalities. The grounds for challenging this order as follows. The petitioner school is a recognized non-government aided educational secondary school. For filling up the vacancy of the headmistress of the petitioner school, the respondent number 3 directed the West Bengal Regional School Service Commission to recommend the name of the suitable candidates. But subsequently, the respondent number 3 passed the impugned order of the transfer without his jurisdiction. The respondent number 3 is not the appointing authority of the headmistress of the petitioner school, which is a recognized non-government aided educational institution. Though the impugned order passed by the respondent number 3 contains that it was passed on the basis of the government order, there appears to be no government order except the order passed by the Joint Secretary to the Government of West Bengal School Education. The Joint Secretary acted without jurisdiction in directing the respondent number 3 to pass an order of transfer of the respondent number 8 from one recognized school, non-government aided schools institution to another similarly circumstanced institution. No recommendation has yet been made by the West Bengal Regional School Service Commission to fill up the post under reference. It is submitted by Mr. Subodhu Talukdar, learned advocate, appearing for the respondent number 8, that there is not a case, a recommendation, but the impugned order is an order of transfer. No material is produced by Mr. Tamobrata Chakraborty, both the learned advocate became. No material is produced by Mr. Tamobrata Chakraborty, learned advocate, appearing for the West Bengal School Service Commission to show that the name of the respondent number 8 has been recommended for filling up the post under reference. No document is produced before this court by the learned state advocate to show there was a government order passed in this excellency. The governor of the West Bengal for transferring the respondent number 8, the post of headmistress of the petitioner school. No provision of the law, no government order is produced before this court by the learned state advocate to show that there is any provision to fill up the vacancy for the post of headmistress of a recognized non-government institution in the state by way of transfer. Let this affidavit in opposition and such as respondents are directed to bring on record their affidavits upon prima facie consideration involved in this case, also considering the submission made on behalf of the respective parties of the record, I am prima facie of the opinion find that the procedure for appointment of the headmaster of the record in non-government institution of the state is prescribed in the section 9 of the West Bengal School Service Commission Act 1997. Upon further prima facie consideration of the fact and circumstances of the case, that neither the above provision is followed for passing the impugned order of, nor there is any provision to fill up the post under reference by way of transfer. In view of the above, the petitioner has not only made out a strong prima facie case, but balance of the convenience and inconvenience in favor of the passing an interim order. In this matter, the impugned order is stayed until further order. Now, my lord, this is continuing. Now, every schools, when she is attending the schools, this is happening, and transfer order is issued one after another. Now, my lord, this order of a stay during the pendency of these stay applications, they have been transferred to the Kankuli. From Kankuli, the same incident happens. They made an application before the principal secretary. The principal secretary again, where the transferred that glorious lady to the Kamala Girls School.
Mr. Bari, would she gain any advantage otherwise in getting transferred so many times? I mean, she could have got a transfer to a favorable place in the first instance.
The Calcutta in the favorable place, in the Kamala.
Oh, on the previous occasions, was she took transfers
No, Howrah to
every time to Kolkata?
near Kolkata.
Near Kolkata.
No, Kolkata.
Akule is that?
Not Kolkata. South 24 Kolkata.
Clear.
Now the entire question is, my lord, whether in violation of the rules, when there is a transfer rules, can it be done by exercising power 10C as Mr. Mujumdar was submitting the 10C, but the 10C did not see the light of the day of that particular.
Vidhan Nagar?
Vidhan God. Transfer order to এটা কোথায় গো?
Anyway, it's okay.
Yes. Now, my lord,
Her initial appointment was where, Mr. Bari?
In Sohuchori, তাই তো? Sohuchori Bihari Vidyapit.
Sohuchori is where?
Sohuchori Vidyapit as a headmistress.
Sohuchori.
Thereafter Joka, thereafter Kankuli, thereafter Kamalagal. না হেডমিস্ট্রেস হিসেবে কোথায়? এই ওইটা দাও না।
Then Sohuchori.
Then Joka. Thereafter Kankuli. Thereafter Kamalagal.
Thank you. Kamala Girls School is in that Power Bazar area. That
no. Kamala Girls is the South Calcutta.
South Calcutta. Very.
Now, your lordships kindly have a look to the. No, compilation of the name. Now, your lordships kindly takes up that application for a stay in volume 1, volume 1, page 80. Now, your lordships kindly, your lordship got it?
Yes.
Can 1.
We filed in map 1042.
1042. Map 104. Page 80.
Page 80, yes.
In cancellation of the previous memo, being number such and such, and in the provision of law laid down by the West Bengal School Service Commission, general transfer on special ground and reallocation rules 2015. They have mentioned that. So 10C, the cancellation of the previous memo number such and such, and the West Bengal School Service Commission General Transfer and Special Rules 2015 issued by the Education Department, Government of West Bengal, by notification number 159 of dated such and such in connection with the general transfer, headmistress of a school from his present place of posting in the school to another school of the vacancy, same subject place, and school education department, letter number such and such. The commission recommends the transfer of the Madhumita Rai school duly opted in a school in the below in the Kamala Girls High Schools. Option was exercised. One of the rules he says that you have to make an application routed through by the managing committee before the DI, thereafter the others, and then he opted for Kamala Girls. And the particular that Madhumita is being recommended from the Kankulit to Kamala Girls as per her choice. Transfer cannot be as per her choice. I made an application for transfer. 2-3 schools are being given. I cannot say that the particular schools, but the Kamala Girls has been mentioned. 194. Well, your lordship, then transfer order of the teaching.
Yes, yes. Absolutely.
Page 194 of the stay application, if your lordship can.
Yes, yes. 194.
It's page the whole. Page 15. Lordship got it?
Yes. You are not getting it. It's not in your copy.
No, this is.
It's the same document.
Now, my lord, this is the letter from to the Secretary West Bengal Central School Service Commission from the Assistant Secretary to the Government of West Bengal. What is the letter? With reference to the subject noted above, the undersigned is directed to forward the transfer petition of the following teachers.
No, this is page 194.
P15, annexer P15, P15.
No.
কোন affiliate?
ওদের একটা কপি নিয়ে দিল।
No, we are dealing with 1042 MAT. Is that that FMA? I will just check up.
Your lordship 1042.
FMA.
No, MAT 1042. Your lordship dealing.
Yes, we are with
your lordship can be 136.
136.
Page 136.
136.
Page 136. The Secretary of West Bengal School Service Commission, this is the letter of the Assistant Secretary. Transfer of the teacher and non-teaching staff different school on special ground. With reference to the subject noted above, understand directed to forward the transfer petition of the following teachers and non-teaching staff different school who have applied for the transfer on special ground. This order issues with the approval of the Honorable Minister in charge of the department. Name of the schools and given, and the name of the Madhumita Rai, serial number 11. This aspect of the matter, recommendation of the ministers of the forwarding has been seriously dealt with by our division bench in the two matters reported decision I am referring them. So, show my lord, my humble submission before your lordships, the total violation of the transfer rule, nobody is permitted to avail that opportunity. Then there is a remedy that you can make an application through the managing committee for it transfer special grounds. And victim of crime, it is not applicable because there was no FIR, there was no police case, nothing else. Moreover, it was made in when the incident was happened, and that after 8 months the application was made to the principal secretary. Although there is no such provision for making application transfer on special ground, before the principal secretary of the schools. Again, I am repeating my submission. 10C did not see the light of the day when Mr. Mojumdar was submitting that 10C can be invoked by the principal secretary, but not on the basis of the applications. But the 10C was not in existence at that point of time. The question of the applicability 10C doesn't arise. Now, my lord, the legal, this is the factual aspect. Well, that is not denied by the anyone. This is a correct. This is a admitted positions. Now, this recommendation of the ministers and forwarding by the minister was taken up for considerations, and in the two judgment I will be citing before your lordships.
What is the recommendation of the minister here?
Well, the recommendation of the minister.
Is it annexed here somewhere?
Yes, well, the 136.
That is
136. A group of 12 persons were recommended. This order issues with the approval of the Honorable MIC.
yes.
The Assistant Secretary is writing a letter to the Secretary of Central School Service Commissions on the basis of this letter. Now, your lordships kindly have a look to this. The judge of the this is the 2017 SCC online, Calcutta 7963, and 2018 volume 3 CHN page 193. The headmaster Bhoteberi, Shitana High School and others, but the Mopita Samadar. Now, your lordships, I shall be relying. Para 16, 19, 2022. Para 16. It would be pertinent to, at this stage, to clear the legal issue arising out of Mr. Rai's interpretation, the rules 3 and 4. The issue is whether a teacher not fulfilling the criteria appearing in Rule 3 can claim a right to be considered for transfer on the premises that she fulfills any of the special conditions appearing in Rule 4. Mr. Datta submitted that this issue ought to be answered in the negative. That has also been Mr. Ghosh's submissions. Answering the issue would require reading the rules in its entirety. General transfer is defined in Rule 2 as transfer on an employee of the schools from this present school of a posting in schools to another place of same category of the vacancy subject and post in another schools. A conjoint reading of the Rule 3, primary condition of the general transfer, and 4, general transfer on special ground, 5, eligibility of the general transfer, 6, procedure of the submission of the application for the general transfer in respect of the teacher under Rule 3 and 4.1c. 7, procedure for general transfer on special ground under Rule 4.1a and Rule 4.1b. And 14, non-concurrence of the rules by the managing committee of the administrator of the school concerned, as the case may be, results the manifestation of the scheme of the transfer of the teacher. Reading such rules one after another, we are of the firm opinion that while Rule 3 provides for the basic condition, one seeking transfer is required to fulfill, certain special conditions are also kept out from the incorporated in Rule 4. A teacher fulfilling the basic condition as a right may apply for and claim consideration of his or her prayer for transfer in accordance with the transfer rule, but it is not quite to the other way round. Fulfillment of the special condition in a given case without fulfillment of the basic condition would not authorize issuance of the transfer even on special ground. The situation is clarified by Rule 5, which appears to all the teachers seeking transfer, including teachers seeking transfer on special ground.
In fact, the caption is also very clear. Forces general transfer on special grounds.
Yes.
So it's general transfer all the same.
And you have to note things, well, the basic condition you have to fulfill.
That's why, because 3 says general transfer, conditions of general transfer, and 4 is general transfer on special grounds. So if it's a general transfer in the first place, then it has to fulfill the conditions.
Yes.
And these general transfer, the basic conditions, and then on special grounds.
Yes. Then, rule basic conditions you have to fulfill minimum 5 years in a particular school.
Yes.
But it has not.
That was the question we were asking on the last occasion. That whether that has to be in each school before each transfer.
Particular schools. The rule says
Because that is
Rule says an incumbent shall be
the appellant's view
eligible.
is otherwise, apparently.
Yes, my lord, your lordship kindly the query, but the reply query of the court reply is clause 3 of the transfer rule.
Yes.
Page 17 of the compilation.
Yes.
Your lordship kindly have a look.
Yes, yes.
Text of.
That's what.
Primary condition of the general transfer. An incumbent shall be eligible for general transfer.
That particular school.
Only, yes, that particular school.
Yes, that is what was, because we asked that question
Yes,
on the last occasion.
So not any schools he fulfilled the 5 years.
General transfer includes only the transfer on distance.
We'll hear you also, Mr. Bandyopadhyay, separately. You just add whatever Mr. Badi misses out, you add.
Although the two different paragraph 1. Although the two different procedures are prescribed by Rules 6 and 7 for submission of the application for general transfer by a teacher, the conclusion is irresistible. The submission of the application for transfer on special ground is hedged with the fulfillment of the primary condition and graft in the Rule 3. Also in terms of the Rule 7.2, the managing committee of the school upon receipt of an application for transfer on medical ground is required to receive the views of the that is the in question of the. Therefore, 3 factors go against the petitioner. First, he had not made any application for the general transfer on special ground after the transfer rules were notified that the post March 11, 2015. Secondly, she did not fulfill one of the primary conditions for general transfer spelled out in Rule 3. She had not put 5 years of the approved service. Thirdly and finally, there being no application under the transfer rule, question of compliance of Rule 7.2 at the end of the managing committee of the said school did not arise, resulting the necessary groundwork for ordering of the general transfer being unable to. So
this particular petition, only the applications to the joint secretary, and those were the only applications.
Only application. Well, astonished. Only application.
Neither of them were routed.
Neither of them. No application before the schools.
Not routed through.
No, not routed through. They said page 15 in the compilation. The application made by the candidate,
yes.
Podumita Rai.
Direct. Yes.
Direct.
We saw that. Yes.
Yes. The principal secretary is in my hand. No problem.
But that was the only application. That's
the only application. On the basis of this application, that's what the record shows. Now, my lord, your lordship kindly. Para 25. Having held that the writ petitioner was not entitled to invoke the provision of the transfer rules, we now move to look at the file that was placed by Mr. Datta. The file bearing number such and such was generated once the writ petitioner came to be presented by the writ petitioner. In such a file, we found a document generated in reference number such and such. It contains a list of the teaching and non-teaching staff of the different schools who had applied for transfer special ground and whose prayers were recommended by the dignitaries. It further proceeds to records that all applications were scrutinized in terms of the transfer rule and findings were noted against each of them. The list contains the names of 48 candidates, majority of whom were recommended for transfer by the Honorable Minister in charge of various departments of the government, Honorable Minister of the States, Honorable Members of the Parliament, Honorable Member of the Legislative Assembly, Secretaries of the Department, Army officers, a Borough Chairman of the Kolkata Municipal Corporation. The name of the writ petitioner appears at serial number 16. Curiously, her case was not recommended by any of the dignitaries. Also, since she was reportedly suffering from high cholesterol, triglyceride, uric acid, sugar, etc., it was observed in the note that she had no genuine special ground. Despite the same, the writ petition name came to be recommended. For the purpose of the decision in the present appeal, we need not embarrass the Honorable Minister in charge of the School Education Department, on whose approval some of the teaching staffs have genuinely ground for transfer on the special ground, reaped in the benefit of the transfer rules, but would record our utter displeasure in the manner which such transfers have been recommended. Suffice it to be recorded that the writ petition was successful in obtaining the recommendation for a general transfer on a special ground, despite clear indication in the note she was not entitled to such special consideration. For the foregoing reasons, we declare that appellants are under no obligation to issue the release order in favor of the writ petitioner based on the recommendation which itself is attempted. The judgment order imputed stands aside and shall stand dismissed. The appeal mat is allowed, therefore shall no order. Before parting, we used to place on record our serious dissatisfaction as to how, without the repetition of being founded entitled to general transfer on special ground, the Assistant Secretary could recommend her name of the transfer to the Chairman of the Central Commission. An appropriate inquiry ought to be initiated by the School Education Department upon granting adequate opportunity to the Assistant Secretary to explain his position and the appropriate action taken against him if he is found guilty. A note of caution is sounded and should any recommendation for transfer be made in future on the basis of the recommendation of the political leaders, such incidents comes to the notice of this court, we would not hesitate to come down heavily on it. Now, my lord,
Mr. Bhattacharya is all the more bound by this judgment.
Yes.
Because of the authors.
And this judgment was delivered in 2017. And other judgment, similar issue.
যে পাচ্ছে রেকমেন্ড করেছে আমার ভালো লাগে জজ নেই জজকে Article 14 has been violated, Mr. Badi. No judge's recommendation finds place here.
That's the recommendation.
If army officers, ministers in charge, members of parliament, only judges are left out. So we should fulfill that gap. In this particular case, in our order, we'll recommend her. Yes.
Para 23 onwards, the fact that the respondent number 10 had served on the post of headmaster of Samchok Jatendra High School
Got a copy
not
of this?
even for a year.
You just give a copy to them also.
Before the trial court, all copies are
right. And they must be knowing this also.
Yes.
Yes.
But the fact that the respondent number 10 had served on the post of headmaster of a Samchok Ganendra High School not for even a year, for he applied for general transfer on special ground, has been raised to the substantial issue that we are called upon to decide whether a teacher who has not fulfilled the condition as laid down in Rule 3 of the said rules could claim consideration for his prayer for transfer on the premises that he has fulfilled the one of the special condition enumerated in Rule 4 for the said rules. Answering such should require consideration of the rule there in the entirety. Now, my lord, the general transfer. General transfer has been defined as Rule 2F of the said rules. Now, my lord, it has been quoted. Rule 20, Rule 4 was also quoted in para 26. Now, para 28.
This is not a reported judgment.
Yes,
Please give the, if it's reported, then please give the citation also. You can just find out the. Have you got the citation? Yes, should be reported. This judgment. If you find out, please just give us the citation so that you can refer. When you refer, we have to.
Yes.
28, para 28. In the meantime, Mr. Bhattacharya, if you can find out, please just give the citation. Or either of you.
Paragraph 20. Though the reading of the appropriate provision should make it clear that the right conferred by the said rules to seek transfer is not an absolute right, free from restriction. On the contrary, the right in the exercise on fulfillment of the various conditions. If any teacher who is yet to be confirmed in the service, or any teacher who has not put more than 5 years satisfactory service in the particular schools and in the particular post for which or 6 general transfer is allowed to seek transfer on a special ground, accepting the contention of Mr. Bhattacharya that the Rule 4 is independent rule of 3, the same would result in the utter chaos and anomaly, creating the administrative problems which might be difficult to overcome. An interpretation of the said rules having the potential of the given rise of the such problem has to be plainly avoided. In the eventuality of an applicant seeking general transfer on the special ground being held not required to possess the eligibility criteria of the general transfer as laid down in Rule 3. An unconfirmed teacher who does not have a right to the post or teacher having served a school on a post less than 5 years could then claim a transfer on the special ground. Similarly, a teacher who has served a particular school in excess of 5 years, but such a service is not satisfactory and disciplinary, proceedings in contemplated against him could escape its rigorous to somehow obtain a recommendation for transfer upon mere fulfillment of the either clause A, B, C of Rule 4.1. Would the said rules permit such a teacher to seek a transfer even on special grounds? The answer has to be emphatic no. What the said rule emphasizes the transfer in either of the two situations, joint transfer whether the special ground exists or joint transfer whether the special grounds do not exist. In place of the claim transfer where the special ground exists, the scheme of the said rules see Rule 6.2 and Rule 7 provide for the claim to be placed in the first track, whereas in the latter case, the cumbersome process of the assessment of the rival claims would have to be restored by first see Rule 6, whether thereafter most depriving would be recommended. Case covered under Clause C and Rule 4.1 are also required to be considered in terms of the procedural laid down Rule 6. But in such a cases too, the applicant of transfer fulfillment Clause 6 would have procedurally heard that the application seeking general transfer not on special ground mentioned in Rule 4.1. But in either case, it seems to be the legislative intent that the condition specified in Rule 3 and 5 have to be fulfilled. So, Shumailar, there is no question. They have not applied, they have not seeking permissions, fulfillment of the applications by the managing committee, making application before the district inspector. Of course, this is an admitted fact. There is none. Then, the para 35, 35 and 38. 38, if you lordships can lead. From the narration of the facts approached, it is clearly revealed that the application of the transfer of the respondent number 10, which was made in February 2015, was forwarded to the government in the education department by the school inspector in June 16, 2016, whereas the application of the writ petition made sometime in the early part of 2016 was forwarded on August 30, 2016. This is the only stage where the respondent number 10 was ahead of the writ petition in the race. However, after processing the application, the school education department recommended the writ petition along with the 6 other assistant teacher of the joint transfer special ground by memo number dated October 24, 2016 of the school commission, whereas the name of the respondent number 10 was similarly recommended by the same department in November 15, 2000. In its affidavit showing cause, the school commission disclosed the exact date. This is the October 26, 2016, when it received the recommendation made in favor of the writ petition by the school education department by memo number such. This memo dated October 24, 2006 has also been annexed by the respondent number 10 in the supplementary affidavit, revealing that the school commission received it October 26, 2000. Despite the receipt of the recommendation in favor of the writ petition as contained in the said memo on October 26, 2000, although the writ petition had opted the collegiate school only, there was a vacancy in October 16, 2016. Commission did not recommend her for appointment there. Instead of the school commission appears to have been under some undisclosed compulsion to wait till November 15, 2000, when the school education department recommended the name of the respondent number 10. At a breakneck speed with 7 days, the chairman of the school commission proceeded to recommend the respondent number 10 for appointment headmaster of the collegiate school November 21, 2016. Keeping the matter of the recommending the writ petitioner to the collegiate school or any other